Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers, where I challenge you to replace a 10th of an hour of billing with a 10th of an hour of learning. For today's episode, episode 6, we're going to talk about modifying irrevocable trusts to achieve the probable tax objectives of a deceased settlor of that trust by adding or maybe even modifying powers of appointment. So before we get into the tax discussion today, we're going to touch on irrevocable trusts real quick. Traditionally, irrevocable trusts are thought of as trusts whose terms cannot be changed. However, since laws tend to change over time, there's been a movement to allow changes in trusts that can adapt to changes in laws, including tax laws. So because of that, the Uniform Trust Code, which has now been adopted in many states, allows for changes to a trust as long as they comply with the material purposes of the settlor as stated within the trust, or as long as the settlor waives those material purposes, if living. So irrevocability of a trust has less to do now with its terms and more to do with transfers to a trust. In other words, a better way to think of an irrevocable trust is one where the settlor cannot take property back once the settlor has put that property into the trust. In other words, they can take it back by sale or exchange, but they can never just take it back without equal value going back into the trust. So why is this important? Because as I mentioned, laws change, especially tax laws, over the last 20 years. Now, one of the most significant changes of the last 20 years has been that the estate tax applicable exclusion amount and the generation skipping transfer tax exemption amount have increased more than 20-fold. They've gone from 600,000 and change back in the year 2000 to now being 11.58 million each in 2020. Now, Section 416 of the Uniform Trust Code allows a court to modify a trust to achieve the settlor's tax objectives as long as the modification reflects what the settlor's probable intention was. Now, intention is usually gleaned from the four corners of a trust, both the express terms and the patterns and customs that are reflected in drafting. And it's rare that the court will look to any external evidence to prove a deceased settlor's intention. The only time the court will typically allow external evidence is if any of the terms of a trust are ambiguous. But when we look at probable intention versus actual intention, it's possible that that can be softened a bit. Now, how far can this be stretched? And the big question for today is, can it be stretched enough to allow you to add a power of appointment to a trust or modify an existing power of appointment? Now, there's little guidance on this specific statute, but I want to highlight the why first, because if a beneficiary dies holding a general power of appointment over a trust, as opposed to a limited power of appointment, then that beneficiary who has a general power of appointment will apply some of their estate tax exemption to the trust and maybe their generation skipping transfer tax exemption to the trust, which could save transfer taxes for the trust over time. And it gives the added benefit potentially of giving a step up in income tax basis for at least a portion of the trust assets on the date of the beneficiary's death. But the big question is it better to add a new power of appointment versus modifying an existing power of appointment? Because most trusts take the modification route when allowing somebody like a trustee or trust protector to change powers of appointment over time. And in the absence of power to that effect, most attorneys assume that you can just simply modify a power of appointment. But I want to tell you the tale of two cases here, which are not widely known, but that kind of reflect where drafting can come into play here. First, the Estate of Smith from the Kansas Supreme Court from 2003 allowed a trustee to add a brand new general power of appointment into a trust and give that to a trust beneficiary. Now, in this case, what helped was not only that section of the Uniform Trust Code I cited, section 416, but also express language of the trust under which the trustees were given the power to take any action to minimize taxes for current and future beneficiaries. So in this case, good drafting saved the day, but the question is good drafting for who? Good drafting for the beneficiaries and that they save taxes, but the question is, did the settlor truly intend for there to be any action to save taxes? Now that's probably not an ambiguous term, but it could be overly broad depending on who you're asking. Now we're going to contrast that case with the Estate of Branigan, which was from 1982, a New Jersey Supreme Court case in which the New Jersey Supreme Court wouldn't allow the trustees to convert a limited power of appointment to a general power of appointment under a testamentary trust. And the reason why they didn't was once again from drafting, which was supposedly good drafting, in that there was an existing limited power of appointment that wasn't general because there was the express language saying that the beneficiary could not exercise that power in favor of themselves, their estate, their creditors, or the creditors of their estate. Now the catch-22 is that that language is there solely for tax purposes to keep there from being a general power of appointment, but the court gave huge deference to those terms and stated that for non-tax reasons, the testator's intent was for that power of appointment to be limited. In other words, the testator of the will did not intend for example, creditors of a beneficiary to ever benefit from the trust, even if it was just simply through the contingent exercise of a limited power of appointment. So in both cases, there was good drafting, but the question is, good drafting for whom? So the key takeaways here is that there's no right answer. This is an area of law that continues to develop, and as long as you have a broad term like probable intention, there's always going to be multiple ways to look at it, as we saw. So you should always ask your client at the trust drafting phase, do you want a trustee or trust protector to have the ability to change the trust terms to maximize tax savings? And how far do you want that to go at the expense of, say, creditor protection or disinheriting a beneficiary in the future or otherwise? And it's important to ask, is it better to add a power of appointment where none existed, or to try to convert an existing power of appointment under the doctrine of probable intent? And as our cases saw, contrary to popular belief, it may be easier to add the power than it is to modify an existing power. Thanks again, everybody, for joining me for this episode 6 of the 10th of an hour. As always, if you have questions or topic suggestions, feel free to email me at griffin.bridgers@gmail.com. Thanks again for joining, and I look forward to seeing you in the next one.